If you're preparing for the RBI Grade B, SEBI Grade A, or IBPS SO Law Office exam, general current affairs modules will cause you to lose marks. Today, we are putting our practitioner's lens on the top 4 corporate and banking law breakthroughs dominating the business grids today. Welcome to the Constitution Code. I am a host, a law officer. Breakout number 1, the Standard Chartered Procedural Shield. The Supreme Court has officially quashed a 23-year-old criminal prosecution against the Standard Chartered Bank dating back to alleged 1991 foreign exchange violations under the now repealed Foreign Exchange Regulation Act or FERA. Reinforcing strict procedural safeguards, the Apex Court ruled that the Enforcement Directorate's failure to prove the service of a mandatory opportunity notice under the proviso to Section 61(2) of the FERA completely invalidates judicial cognizance. More importantly, the bench held that alternative remedies do not bar a High Court from invoking its inherent powers under Section 42 of the CrPC to protect an entity's right to a speedy trial under Article 21. Breakout number 2, the RBI moots the Foreign Investment Rules 2026. The RBI has released the draft Foreign Exchange Management Foreign Investment Rules 2026 for public consultation, completely seeking to replace the existing Not Debt Instrument or NDI rules of 2019. For exam sheets, note the two most substantive conceptual shifts. First, the explicit capture of indirect cross-border investments through foreign-controlled entities within the primary definition of foreign investment. Second, the complete simplification of pricing guidelines mandating equity transfers from residents to non-residents to be executed precisely at the fair market value, removing the previous pricing flow flexibilities. Breakout number 3, demerger and segregation jurisprudence. Delhi-based real estate giant Anant Raj has officially approved a composite scheme of arrangement to demerge its data center and cloud services vertical into a separately listed entity called Ashok Cloud. From a corporate law perspective, this execution triggers the intensive court-monitored scrutiny provisions under Sections 230 to 232 of the Companies Act 2013. The restructuring establishes legal precedent on how cross-border digital infrastructure lines can carve out management autonomy while preserving long-term shareholder equity valuations. Breakout number 4, the Safe Harbor revision for Frontier AI. The Ministry of Electronics and IT is conducting a rigorous regulatory gap analysis of the Information Technology Act 2000 and the India AI Governance Guidelines. Government authorities have confirmed a massive rethink on the liability framework for frontier large language models. The state is proposing to dilute the traditional safe harbor protection under Section 79 of the IT Act, arguing that developers cannot escape liability for synthetic media or illegal content generated autonomously by their proprietary tools. Stop wasting hours trying to escape law codes from financial news walls. We compile, filter, and code these exact executive matrices into 2-minute whiteboard grids every single night. Hit the subscribe button to join the Constitution Code. Master the real world application. Let's secure that rank. See you tomorrow.